Thank you very much. First of all, I would like to apologize for being late, but unfortunately, due to the time difference, my calendar has shown the time for speech like 2 hours after rather than before Minsk time. So my apologies once again, but I'm very happy that I'm ready to be present and to speak on this webinar. And I would like to start with thanking the organizer for thinking of and putting efforts to organize this important event. Because today, the development of industry and development of business is indeed affecting human rights a lot in all spheres of our life. And as UN Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights, I will try to show you a very specific area of relation of business and human rights, which usually is pretty much neglected, but which is very important today, as I can see, while being the mandate holder and while doing my job as a mandate holder. Naturally, the problem of business and human rights is in the focus of attention of the world community since already dozens of years. And indeed, that's a very important problem. And the United Nations has established a working group, also being a part of the special procedures in the same way as my mandate. And this business and human rights working group is focusing on the rules which both business and states are supposed to follow in order to protect human rights while doing the business. And this working group has is developing some documents as well as following the specific requests. And the United Nations has adopted some rules, like, for example, the guiding rules on the business and human rights. And if you look at these documents, you will clearly see that the principles themselves are split into two main parts. So the first part is focusing on the obligations of business. And if I sum up all businesses, and we speak here not only about industries, but we speak about all sorts of companies in every sphere of involvement, are obliged to do their best to protect human rights and to prevent human rights from being violated. The second part of the principles is focusing on the obligations of states to demonstrate the due diligence principle while regulating and controlling functioning of business enterprises on their territory or on the territories under their jurisdiction and control. That basically means, and the guiding principles on business and human rights are repeating the due diligence principle, which has already been formulated in the middle of the 20th century. I will refer here back to the decision of the International Court of Justice on Corfu Channel case of 1946. So all states are obliged to take all necessary measures to guarantee and to establish the conditions for business to observe human rights while acting on the territory of states or under their jurisdiction and control. And that's why, while speaking about the problems of relation of business and human rights, we need to take into account that we speak about two different kinds of actors. From one side, we speak about obligations of business enterprises to protect and promote human rights. And from the other side, we are speaking about obligations of states or huge regional organizations to guarantee that business enterprises on their territory protect and promote human rights. That means that states are obliged to develop necessary legislation, to introduce necessary control, and to provide necessary mechanisms for redress in the situations when activity of business violates human rights. Unfortunately, the problematic of business and human rights, while being very diverse and while being assessed from very different perspectives, and dealing, for example, with the obligation of states and businesses to introduce green labor standards or to prohibit discrimination in various forms, and many other elements, unfortunately, this problematic is omitting a very important sphere. It omits the spheres what are the duties of states and businesses in the face of unilateral sanctions. And that's the problem on which I plan to focus today, because unfortunately, there is nearly no regulation in this sphere. And as in many other areas, the problem of application of unilateral sanctions have quite often forgotten when we speak about function of different United Nations mechanisms. I will cite here, for example, the very recent report of International Labour Organization about situation in Venezuela. I give this example in a view of the fact that my recent country visit was to Venezuela, and I will present my findings on country visit in 2 weeks to the Human Rights Council. And the International Labour Organization is absolutely correctly citing problems which are faced by people working in the country, like very low salary, the incompatibility of very low salary and the food basket, the malnutrition of people, very low social guarantees, the involvement of more than 40% of the population of the great economy. But it doesn't, in all 250 pages, it doesn't say a single word about the impact of unilateral sanctions to the situation and the impact of unilateral sanctions to labor rights, as well as the activity of the businesses. I would like to elaborate a little bit on the point. I met a number of people being founders or working for both public and private enterprises. And unfortunately, it has happened that they all were pretty unanimous about the impact of sanctions. They all are referring to the huge impediments in buying products to be delivered to the country under sanctions. Public companies are nearly cut off of any possibility to bring goods in the country. Private companies refer to the fact that, generally speaking, it's possible to do that, but the problem is that they have to do it via several mediators, because as soon as the nationality or place of registration of the company is revealed, the counterpartners prefer not to deal with that any longer. And as a result, the price of goods is increasing enormously. As a result, public companies which can't do their job in a normal way anymore, they have to lower the salary of people which in the countries which are already facing some sort of economic crisis, or they shall stop working contract, and people stay jobless. They have the level of unemployment and level of poverty rises. People are becoming involved into criminal activity or used for human trafficking or the black transplantation or any other sorts of illegal activity being misused, and they face all negative consequences. I will elaborate a little bit what I'm talking about when I speak about application of sanctions. When we speak about the problem of business and human rights, we need to take into account all possible sorts of sanctions. It's not possible to say, for example, that these type of sanctions is affecting people and is affecting businesses a lot, and another kind of sanctions doesn't do that. Naturally, when we speak, for example, about the direct targeted sanctions aimed at the owners or aimed at the specific companies, we see the direct effect. As soon as companies or sanctions or banks that's affecting even more people are listed under sanctions, that basically mean that they can't do their job normally any longer. That basically means that no foreign counterpartner will be ready to interact with that company, and the employees of that company will face all negative consequences of the decreasing economic activity of these businesses. However, in this situation, we see the direct effect of unilateral sanctions applied to specific companies. However, the effect of unilateral sanctions is much broader. When we speak about the countries being subjected to economic or sectoral sanctions, as for example Venezuela, as Iran, as for example Syria, and many other countries, imposition of sectoral sanctions as well as economic sanctions basically means that all counterpartners as well as all other foreign companies will be very reluctant to involved into any economic transactions from the companies registered in the specific sector of economy or countries registered in a specific country. And in this situation, again, we see a direct impact of sanctions to the individuals. Although companies are not listed directly, as soon as they involved into the specific sphere of economy, they become targeted. And that means that the lives of people working for their companies as well as their family members are affected a lot, because the company can't pay their salaries any longer, can't provide the maintenance it used to provide before. If company doesn't have money, it doesn't have any revenue, it's just impossible to get any profit. They have to stop labor contracts of these individuals. At the same time, today we are facing even more expanded impact of so-called zero-risk policy and over-compliance in the situation when companies or sectors of economy are not targeted directly. Today, the types of sanctions and the number of sanctions is so enormous. I can refer, for example, to economic sanctions, financial sanctions, banking sanctions, sectoral sanctions, targeted sanctions addressed to specific individuals or companies for allegedly doing something wrong quite often without any jurisdiction to make people or companies responsible in this specific situation. And quite often targeted sanctions against individuals or companies for being involved into transactions with already targeted companies. All these, and I will also say that quite often sanctioning states are introducing punitive legislation, providing for civil and criminal penalties in this situation when companies, their own nationals on their own companies, are involved into transactions with companies already listed or companies from the countries which are under severe sanctions. All that affects, first of all, the banking area, and Iran is facing this problem enormously. For a long period of time, the majority of public banks in Iran have been listed, and that basically means that people couldn't do any transaction within this system, and neither the country nor private companies or individuals couldn't do any payment. Less than a year ago, the last 18 private banks of Iran were also listed by the United States. And as soon as all the banks all around the world are working in the system of correspondent banks, that means that they would prefer not to do any business with banks being listed in Iran in this specific situation, in order to avoid any negative consequences or decision of, for example, American banks to trade with them through the system of correspondent banks. It all results in the fear of sanctions, especially in the banking sphere. It results in the expansion of the time for consideration of the security of request for bank transfer, in the growing payments to do any bank transfer, the growing number of rejections to do any bank transfer, and the choice of so-called zero-risk policy from the sides of the bank. That basically means that because of this direct listing, indirect listing, and over-compliance and zero-risk policy, quite often, and it happened in Iran as well, individuals or companies are not able to do any bank transfers and do any bank payments because of the imposition of unilateral sanctions. These people or companies may be not directly listed, but they are affected nevertheless. And as a result, I'm dealing now with a number of complaints which come from different countries all around the world about the impossibility to bring food to the country, although food is traditionally considered to be well-recognized humanitarian exceptions, as well as to order the medical equipment and any other essential goods. I have been reported about the cases when banks have frozen assets to prevent companies, to prevent payments which were supposed to be used to buy vaccines, to buy medical goods, medical equipment, some sort of medical clothes, to do in transplantation cases for oncology patients, as well as many, many, many other vital situations. I have certain statistics about people who have died in specific countries because of this specific disease, because of being unable to get necessary medical treatment in the country or abroad, because of being unable to get necessary medicine. I believe the most broadly discussed situation in Iran was concerning impossibility to get insulin. There are thousands and hundreds of thousands and millions diabeticals all around the world, and their life is endangered if they do not have access to insulin. And in any case, even for those who can survive without that, the lifestyle and the quality of life is deteriorating a lot. The same situation, the impediments from the side of the bank system to do financial transfers, as well as the overcompliance and the fear of companies to be involved into any business, results in the impossibility to buy any sorts of goods. So companies which produce medical equipment are not ready to provide various sorts of medical equipment, materials, medicine, and spare parts to the companies from the targeted societies. The same situation exists when we speak, for example, about spare parts or equipment or reagent for life-saving or essential systems like electricity system, water supply system, gas system, gasoline production system, and many other of them. As a result, these, beside the direct effect of unilateral sanctions on businesses, and as a result, the indirect effect of unilateral sanctions on human rights, there is this indirect effect of unilateral sanctions on businesses and human rights because of the overcompliance policy from the sides of banks as well as other companies. Because of the complaints which I have already received, I'm trying now to communicate to the banks as well as companies as well as states, requesting them to observe guiding principles which have been already established by the United Nations system, and to request businesses to behave in the human rights protection friendly way, and to request states to behave in the same way, to provide the businesses with the possibility to do their business in human rights friendly way. I believe you have quite often heard about the problem of extraterritoriality, when unilateral sanctions as well as punitive measures are imposed in the absence of any jurisdiction. And that's mostly the United States sanctions which are recognized to do that. And I can cite, for example, the materials which have been prepared the European Union, which is also imposing a lot of sanctions. But the European Union parliamentary documents, as well as a number of other documents, and there is also a regulation dating back to 1998 and recently updated repeatedly, which refer to the fact that the European Union business is affected a lot by the extraterritorial, extrajudicial application of the United States sanctions. The European Union has even brought a case to the WTO dispute settlement body more than 20 years ago, but has withdrawn the case afterwards and implemented this regulation trying to protect its business. But even the European Union business is affected by those countries, by the United States sanctions, and is still following the over-compliance mechanism. It's possible to speak a lot about the effect of the business and the clear examples referring to Iranian situation. I can cite, for example, a case when a number of Iranian vessels were delivering gasoline to Venezuela, suffering because of the shortage of gasoline enormously, and the company themselves, as well as the captains of the ships delivering the gasoline, have been directly listed by the United States, proclaimed to be involved into terrorist activity, and information about them has been placed under the Reward for Justice program, which affects the rights of these individuals as well as the staff of the companies directly, but affect the lives of people, not only Iranians, but Venezuela, in Venezuela population a lot. I believe I will stop here and I will be happy to answer any questions.
Thanks, Dr. Douhan. Many thanks for this informative, interesting talk. Thank you so much. As you know, it's a kind of justification for business enterprises that okay, our hands are tied. It's something coming from the top, decision makers internationally or domestically. So as this is a topic that we are not, going to talk about today, policy making or, this kind of the roots of this unilateral sanctions, whether they're justifiable or not, or the political, political aims behind this kind of measures. But the issue is the term that I like it very much, the term from the 80s literature about the footlooseness of these companies, these business enterprises, that how footloose they are. And could we, in many cases, they could disappear over of presence of multinational companies or foreign companies in our country, and this footlooseness and this one-night disappearance has severe irreversible side effects and impacts, mainly on local communities. I would like to know how, to what extent this kind of footlooseness is justifiable, based on this. Our hands are tied because of the, because of the political decisions or political statements like this kind of unilateral sanctions. As you know, we do have these Sullivan principles that were applied in the 80s, I guess, in South Africa. And so we do have this kind of measures that could be taken as an initiative by companies, by multinational companies or foreign companies, as a kind of a preventive measure to protect people's humans or local communities or even the environment, and to protect them and to prevent negative impacts from happening to this kind of groups. To what extent this kind of measures are protected or are recognized at the first place or protected? So to be more clear, I want to know, is this a good justification that as a business enterprise we cannot do anything further than what our government or the international community asks us to do?
Thank you very much for the question. I believe that I see it at the whole scale of questions, not a single one, and I will try to touch some of the elements. It shall be taken into account that my position when I'm speaking about unilateral sanctions is that I never intended to say that states cannot take any unilateral measures. They can, but they can't take it as long they follow the rules of international law. And therefore, states naturally can apply certain means of pressure towards other states, but again, in accordance with the rule of law. Unfortunately, today, the majority of measures taken by states in the form of unilateral sanctions do not correspond to the rules of international law. And I will cite only one point. It has been universally recognized that one of the criteria which shall be taken into account is the humanitarian impact of activity taken. Even the UN Security Council, which is entitled to take international sanctions under the Charter of the United Nations, is taking account humanitarian concerns, because after the so-called decade of sanctions of 1990s, it started to be clear that humanitarian impact of these sanctions is enormous and scary. And the UN Security Council changed its policy and started to follow the humanitarian standards. Unfortunately, unilateral sanctions do not follow this example today. However, if you look at every document which introduces a sort of unilateral sanctions, it usually refers to the possibility of humanitarian exceptions. And it usually said that the measures imposed, they shalln't affect essential goods like food or medicine or any other sorts of essential goods. And as a result, states which impose unilateral sanctions traditionally say, look, the legislation which we provide intends to observe human rights, that the companies, they are private companies, and that they are wrong in this situation. When I talk to a number of companies, including banks, they have a totally opposite approach. They say, we are eager to protect human rights, and moreover, our own businesses are affected by unilateral sanctions. We do not welcome them at all. At the same time, it's very complicated to introduce humanitarian license. We do not have an enormous staff to do the job to check which one specific individual or company is listed or not listed, and that's because of states which impose these multiple and sanctions which impose punishments. We do not want to be subjected to punishment. And their fears in some cases may be subjectively justified. If we recall, for example, the Paribas Bank, which has been which is facing the penalty to pay $9 billion. That basically means that the bank is bankrupt, and the whole system, banking system, involved in the activity of the bank is bankrupt. And there are a number of other banks which have been facing fines of somehow lower, but still resulting in the bankruptcy. And that's why be scared of prefers human rights like at the last point, not at the first one, because they want to keep your attention to the problem of so-called shifting responsibility. When states try to shift responsibility to private business in the sphere of human rights protection and the violations happening because of application or implementation of unilateral sanctions. On the opposite, businesses intend to announce that they just follow the rules or legislation of nation states, and they do not recognize their responsibility. I have been repeatedly reported that there are some cases of threats which have been received by businesses from the side of specific governments to behave in one way or another. And unfortunately today, when we speak about the business and human rights, this problem, as I have said at the very beginning, is forgotten. And that's why human rights of workers, human rights of all population, the environment, and many other aspects are affected a lot. And my opinion is that today, the only way to settle the problem and to find the solution is to observe the rule of law. And as much as it refers to the problem of the business and human rights, implementation of guiding principles by both businesses and states is very important. And that's why in my work, I'm forwarding communications always directly to the businesses and to the country where businesses is registered, referring to the same document, but just the different parts of the one. Any other questions?
Yeah, many thanks. I was wondering to know, that this indirect impact of unilateral sanctions, as you mentioned, medical products are always excluded from sanctions, but there was a case that Dr. Zakir Hussain is following, I guess, and it's a kind of avoidance license for companies. It's something that sanctions. You always hear that, and in some cases they're not directly related to sanctions, but it's a gateway for companies to dodge their human rights obligations or their humanitarian obligations, and it's a kind of justification for them. Many thanks. There is a question. One of our audience, the raised hand. Okay, Mr. Nazarnejad, you could talk. You could open your microphone. Could you do that? Now would you please try that, Mr. Nazarnejad? I'm not sure how to, yeah.
Can you hear me now?
Yes.
Okay, perfect. Hello, Professor Douhan. Thank you for your great presentation. I've got a few questions and I try to ask them as quickly as I can. The first is that I don't know whether you've heard about the principles of responsible investment developed by the international investors and financiers that was resulted in this resolution by the United Nations. I was wondering if you'd mind shedding a little bit of light on the matter and telling us how successful that principles have worked on European and American continent. And the second one is that as far as we see, human rights principles show themselves in the implementation of contracts as the civil liability or other types of the conditions that are included in the contract. So I was wondering if there is any type of sustainable contractual regime which preserve the principles of human rights. Is it possible to bring the human rights system into a really higher level, incorporated in all the contractual cycles that corporations and the multinationals use or not? Thank you very much.
Thank you very much for your question. I believe that these questions are more appropriate to the High Commissioner rather than to me, because I'm just a special rapporteur. That's why I will try to limit myself to the scope of my mandate and some, let's say, knowledge of the academic in this sphere. I need to admit that I'm not dealing with the principles of responsible investment. That's why I wouldn't comment on the point. However, when we speak about the human rights standards implemented in the function of the businesses, that was this purpose, what exactly the one why the working group on business and human rights was established. Because unfortunately, we face today enormous number of questions in the sphere of business and human rights, starting from transnational companies. Some of them have exacerbated a lot with the movement to the distant work and online work in the spheres of social guarantees and many others. As for now, I believe that we can hardly expect any binding document like a treaty. At the same time, as you know, in the international area, states shall come to the point when they are ready to conclude a specific documents. And as for now, I believe that at this stage we are limited to the area of guiding principles or certain declarations as a basis for formulation of the customary rule of international law. However, I believe the very important starting point is the universal recognition that the principle of due diligence in the functioning of all sorts of enterprises and the principle of due diligence in the functioning of all states is applied to the sphere of business and human rights in the same way as it has been previously recognized. It was involved to the law of international security, law of international responsibility, international environmental law, and many other spheres as a customary rule of international law. And it shall also not be forgotten that obligation to promote and protect human rights is a universal standard, a universal customary obligatory norm of international law. Our problem and our purpose now is to formulate how specifically these norms will be applied in the sphere of business and human rights, but we already have an obligatory norm as a starting point for development. Any other questions, maybe?
Many thanks. Is there? Well, is one more question about the COVID vaccines and unilateral sanctions and Iran being deprived from getting access to vaccines because of unilateral sanctions. Have you heard anything, or have you received any kind of reports about this issue?
As for now, I didn't receive a direct communication as concerned the problem, but naturally I'm following the problem. Last year, when I was preparing the report about the impact of unilateral sanctions on human rights in the course of the pandemic, that was the starting attempt to look at the point, although there was no vaccine developed at that point yet. As for today, indeed, a number of countries are prevented from getting access to the vaccines, or sometimes they have faced serious problem in payments for the vaccines against COVID because of sanctions. Namely, as I said during my last Venezuela country visit report, that was one of the problems which has been observed. And for example, Venezuela is participating in the COVAX program. It faced serious problems as concerns unfreezing of funds to be used for the vaccines, and even when the funds have been unfrozen, the banks have frozen the payments and such. And the cases have been reported for other countries as well, especially when the whole banking system of the country is frozen. I repeatedly called, starting from the moment when the COVID pandemic has started, that unilateral sanctions shall be lifted in general, and they shall not affect the cooperation of states in the sphere of medicine. The same statements have been made by the High Commissioner and the UN Secretary General, directly aimed at the COVID situation. The vaccine has been recognized, and access to the vaccine has been recognized as the thing which shall be of universal value, but it doesn't happen in reality, and it's not happening yet. And from one side, I'm happy that some countries are assisting each other in provided COVID vaccine. From the other side, unfortunately, I see that we do not face the universal response to the problem of COVID in the way it shall be done. It refers to the vaccine situation as well.
Okay, great. Thanks for your presence. Thanks for your very informative, interesting talk, and thanks for your time. Many thanks, Dr. Douhan.